Welcome, everyone. I'm very pleased to be with you here. I first want to thank Karim for really taking up the challenge and whipping this meeting together, this great meeting together, in the circumstances that we all know. I think the lab has done a fantastic job of making this happen and making this happen well. I wanted to thank particularly Maria for stepping up to a considerable logistical challenge. Maria has become, as you can see, an expert, a Zoom expert or a Zoom master, and she's been amazing support in the lead up to this meeting. Thank you, Maria, and congratulations. So what I'm here to do this morning is not to take up too much of our time, but just go over some of the highlights of what's been happening in Working Group 2, which is about conflict resolution, if you recall. I will go through this by sub-project numbers. We have number of sub-projects. You see that we have sub-project 5 and sub-project 6, which are both on ODR platforms or system. You will recall that the Consumer Protection Agency project was one of our ODR case studies. This working group is led by Jean-François Roberge. It started before the Condo Authority sub-project, which began this year, as Karim mentioned earlier. So we realized after sub-project 6 on the Condominium Authority Tribunal that the groups were both looking essentially at the same issues, notably at the challenges of measurement, of evaluation, and the challenges that concern design. And so the work of sub-project 5 and sub-project 6 were essentially merged. And Nicolas Vermès and Jean-François Roberge are working together on in what is clearly the most active group in Working Group 2. And so they set out to restructure the project now around 3 case studies. The Consumer Protection Agency platform was one. The Condominium Authority Tribunal of Ontario was the second, that started this year. And now added to this is the Civil Resolution Tribunal of British Columbia, which was added as a third case study. This makes for a nicely pan-Canadian project, as you can see, with one case study in British Columbia, one in Ontario, and one in Quebec, and they all do slightly different things. As you know, the Civil Resolution Tribunal of British Columbia is about small claims. It was put online a while ago and has some interesting data. The Consumer Protection Agency platform is about consumer to business matters, and the Condo Authority Tribunal is about specific issues and disputes that arise in the context of condominiums in Ontario. So in terms of research themes, they're very broad research themes that were identified for all of these case studies. There are 2 main themes. The first one is about platform design. So how to better present information, how to better structure the information, and how to structure the processes to reach for an ideal result. Of course, this depends on the objectives that we set out to achieve. And this is partly, there's a virtuous circle going on here, depending on the results of evaluation based on empirical metrics, and that's the second research theme. How do we measure success in ODR? And this is a considerable challenge for the following reason. ODR has been defined in many different ways, but a broad definition would include basically everything that is relevant to access to justice. And so if you're looking at the broad platform or the broad system, you're looking at communicating information in a way that draws in the users. That's one stage that the platform design has to take into account, and that the objectives of a system has to take into account. A second stage would be orientation of the user, and it's really important how you take the user by the hand and go to the right place with that user. So that's orientation. Then there's usually a possible negotiation stage with another party around a dispute, followed, if needed, by a negotiation stage. That's another possible stage in such platforms, followed by an adjudication stage. So there are many, many steps. And the last one, if you're looking, for example, at smart contracts, you're looking at possible execution of a decision or adjudicative decision or judgment, which could be tied into the platform. So platform design there's a lot to do. It's a huge endeavor, as is the question of how to measure success and how to identify the objectives that we're pursuing. Moving on to the next slide, we're still with subproject 5 and 6. Some priorities were identified by the partners in the course of last year, and some of those, probably the most important, is to establish a comparative framework to measure the cost effectiveness of ODR, and that's in particular compared to the cost of justice as we traditionally see it. And this again is a considerable challenge because in order to compare courts, you need to have reliable data, you need to have aggregated data, which we don't really have. It's very scattered in terms of what is available. But there's a clear need and demand, particularly within departments of justice, to show, to establish with numbers, with hard data, that ODR is indeed cheaper, or that the state or government or jurisdiction will be saving money by investing in ODR platforms and mechanisms. To the actual direct costs, one has to take into account, obviously, the socioeconomic costs of a failure to provide access to justice. And this is, while relevant, it's obviously an extremely difficult thing to measure. But this is a challenge that the subgroups have taken up. And it's important, I think, for us to show for research to provide reliable data comparing what ODR does in terms of delivering access to justice. There's another priority that was raised is the need to measure and to further study the role of the human support factor on ODR platforms. This includes the need and the stage at which a human gets involved, how much you can achieve without the human on the one hand, and on the other hand, it involves the possible investment in getting helpers to help vulnerable people who need assistance in using such systems, for example, the elderly. So this joint sub-project is highly active and highly productive. I got a list of the events that they organize, which is considerable, as well as the publications. So I move now to sub-project 6, which is about distributive justice with immersive technologies, led by David State with Frederick Lederer. You will recall, most of you will recall that a system was built by David in Australia and successfully tested under laboratory conditions. This is a system that allows people to feel like they're in a physical space when people are on screen. And I think many of us have seen a demo of this or a video showing how this works. It's quite impressive, and the work that is going into the coming year now is to build a portable facility for wider use, sort of a portable system. And so industrial partners, including Linux, if I remember correctly, were approached to build the required software. From what I understand, the key to success here would be to build a control panel that the decision maker can use, that is the judge or adjudicator or arbitrator, something that is user-friendly and allows one to control the cases as well as what happens in the virtual courtroom. Obviously, timing is quite important. Fred, in one of our recent meetings, Fred highlighted his contact with the judiciary and the bar in the US and pointed to a consensus that distance hearings will definitely stay with us after the pandemic. It's not going away with the virus. And so this is extremely timely work. There's a great demand. Once people have started using the basic technologies that they're currently using, they will be looking for more in all likelihood. There's also ongoing work within this sub-project on the fairness of virtual hearings in criminal matters. This obviously raises very significant human rights concerns. There've been studies on virtual juries involving, in particular, Meredith Rosner. This work is started in the past year and is ongoing into the next year. I move now to sub-project 8, which is about self-represented litigants. So the significant work has been done with our partner CLIO, the Community Legal Education of Ontario's. They have what they call a guided pathways products. We've been working on the family law product. They've just launched a few weeks ago a new pathway on powers of attorney. There was a webinar organized 2 weeks ago about that with the launch of the product. What we've been doing is to build a model for evaluating ease of access and use and impact on the user and more generally on access to justice. So we've been working with McGill doctoral student Alexandra Pascal. She's working under my direction at McGill, and Clio staff lawyer Eric Hornman. And they're building on evaluation models that have been deployed on tools that are also using the A2J author system in the US. This has been implemented by state courts in many places. We're now adding to the team a master's student who has legal training and is working with Linda Silva, one of the researchers of our project in information science. Her name is Sarah Delière-Boulal. If I'm not mistaken, she's with us this morning. Good morning, Sarah. We're in discussion within this subgroup with Justice Quebec to make the small claims online form that has been deployed recently also a case study where we might adapt and deploy the framework that we're developing with Clio. This is complicated with Justice Quebec because there are many moving big pieces. Justice Quebec is looking from different angles at what it's trying to do to make things move in the direction of online dispute resolution. And so there are several projects that are being looked at the same time. So this is ongoing. There's also a rapprochement that we're thinking about with sub-project one within working group one, which is on pre-conflict decision tools for litigants. Obviously, there is some overlap there. And finally, I moved to sub-project 9, which is about decision tools for practitioners and decision makers. This is led by Fred Lederer. There's ongoing work going into the coming year with the disciplinary board of the California State Bar. If you can believe it, they have 16,000 complaints against lawyers every year. It seems like a rather large number of complaints for lawyers. So Carl Branting has been doing this research, and they're working on ways to triage and working on prediction with the considerable data set that this provides. It's been very difficult to improve the system, but they're still working on different strategies. Work has been done on the potential of game theoretical algorithms in the justice system. This is led by Marco Giacalone, who's with us this morning. I understand he sought EU funding for further work going into the coming year on the same subject. Work was also done on the theory, both the potential and the limits of prediction through computation. This is highly theoretical research, and this is done by a new researcher whom Karim introduced this morning, Jean Lassegue, who's at CNRS in France. I think in France, yes. The projects for the coming year include a non-technical explanation for the bar and bench on what AI is and what it can do and cannot do. It's a kind of a report or a book or a tool for both the bar and bench to explain what AI is. And this comes from the realization by Fred through his contact with the bar and the bench in the United States that there's a huge amount of confusion as to what AI is and what it can do. And it would be helpful to help the bar and the bench understand better what is possible, what it is, and so on. So I will stop here, thanking you for listening. And if you have questions, I'll be happy to take them. I might hand them over to my sub-project leaders if you have more specific questions. Thank you.